important item, so I've set the afternoon aside for a hearing on this particular bill. It's the sovereign immunity. And to give a little background in history, I'm not going into all the detail of the court decisions, but we've had over the last several years several decisions out of our state Supreme Court that have brought about an understanding that we do not have, apparently, the ability to bring legal action for injunctive relief or declaratory judgment against the state, its agencies, departments, our personnel in their official capacity, or as to counties, or as to cities, we believe. And these decisions and the law that we're talking about grows out of Georgia Department of Natural Resources versus Center for a Sustainable Coast, which is at 294 Georgia 593, a decision that came out February 24th, 2014. Additional cases, we have the O'Vera versus University System of Georgia, Board of Regents 298 Georgia 425, which came out approximately 2 years later on February 1st, 2016. And then a most recent decision is the Lathrop versus Deal, which was decided in 301 Georgia 408 on June 19th, 2017. As a result of these decisions, we are today looking at a bill that addresses putting back into pretty much the way we thought the law was prior to the initial decision, and that is to allow individuals and businesses in our state to seek relief in the court as far as relief by injunctive action or declaratory judgment, where appropriate. And another part of the history is we had a bill that was brought in 2015, passed the House that year. The next year it passed the Senate, and it was addressing in a statement of the same thing as far as the clearing up the issue of sovereign immunity. Passed both houses in 2 years and went to the governor. The governor felt it was necessary to veto it. Felt it was a little too broad for what he felt needed to be done as far as the state parts of it. Since then, nothing happened in 2017, except that the governor appointed a commission, I guess would be the better term for it, which was to study several things regarding judicial changes. And one of the charges given to that commission was to review the provision of Georgia laws and the cases on sovereign immunity and make a recommendation. In a brief statement, the recommendations really came back not making a recommendation as to how to address sovereign immunity, other than to say something probably should be done about it, and leaving it really up to this legislative body, I guess, and the governor to address that. So what we started out doing was I brought I, as the primary sponsor, brought the bill that was done back in 2015-16 in a restatement and filed that as a bill. And the governor, through his floor leader, Chuck F. Stration, brought a bill in the House which was to address the state's issues on sovereign immunity. I have taken it upon myself to really combine both those bills into one bill, and using the vehicle of the Chuck F. Stration bill, which is House Bill 791, we are going to be going forward with a review of that bill, and I want to give you the appropriate number. It is House Bill 791, which is LC 297905. So if the committee members in your folder, you should have that bill, and you probably will have the original bill that was introduced in both cases also of House Bill 791, and the bill I had, which got the number off the top of my head, I'll look at it here, 674. So 674 and 791 have been combined into a committee substitute, which is the one I just referenced as being 297905. We have our Legislative Council today, Julius, with us. And Julius, there will be, this is a 29 bill draft, which was being done by Jill Travis. She is going to come over to sit with us during the hearing on parts of this, in case we have questions or changes about that. But we're opening up the public comment, and I would like to say we got a sign-in sheet. We want to have the persons who'd like to speak to the committee regarding the issues of the bill, sovereign immunity, and the language that we have incorporated. Please do sign up. I want to first also recognize an old dear friend of mine, Judge Bill Hamrick, who's with us today. Judge Hamrick in his youth was a state senator. And he and I worked very closely together for several years. When he was chair of the Senate Judiciary and I was heading up the House Judiciary, and so we'd compare things at the crossover date and say what we're going to do with them and try to work out a plan on it. I think we did pretty good at it too over the years. So glad to have you with us, Judge. Are there other judges in the audience that I failed to recognize? Guess not. Okay. If you will pass that sheet up, please, and let me take a look at it. And I know we have several folks who'd like to talk about it. And first is another good friend of mine, Larry Ramsey with the Association of County Commissioners of Georgia. Mr. Ramsey is a lawyer of long-standing, Duke graduate. Glad to have you with us.
Thank you, Mr. Chairman. I'm very happy to be here, and I appreciate being able to speak to the committee today about the substitute. I saw, as the chairman indicated, the substitute on the original bill on the state. Local governments have been added to this substitute, and I would ask the committee to suggest a couple of what I think are very minor changes in the substitute. And for background, in lines 47, 48 is where the bill talks about the extent of the waiver for state claims. And it says that declaratory and injunctive relief is available to prevent the enforcement of a state statute where the claim is that that statute is in violation of the Constitution of the state or of the United States. My suggestion is to have similar language as to local governments, and the relevant lines there are lines 106 through 109. As a little background, as the committee heard me say, when House Bill 674 was before you, it is difficult to argue from a policy standpoint that citizens should not have some basis to assert their constitutional rights against any level of government, and I'm certainly not speaking against that. I think a waiver for injunctive and declaratory relief makes sense. But as far as mirroring up the new local government language to what the bill has for the state, I would suggest 3 wording changes, and then I can provide to the committee later if the chairman is interested.
You go ahead and speak to them now. If
Yes, yes, sir. On line 106, my first suggestion is that between the words relief and to, that the phrase from the enforcement of a local ordinance be inserted. Again, that would match up with what the bill already says about state statutes preventing injunctive or declaratory relief against the enforcement of a state statute. This would simply mirror that where we're talking about a local government seeking to enforce an ordinance. Then on lines 107, 108, and I'll explain this in just one second, I would suggest deleting the words without lawful authority beyond the scope of its official power or. So what that would leave us with is these claims could be brought where the claim is based on that the ordinance is in violation of the state or federal constitution or a state statute. The reason that I would suggest taking those phrases out. And if you've done local government before, you may know that there's a long-standing line of case law for a couple hundred years that says that local governments only have those powers that you can specifically identify in state law. It's called Dillon's Rule, if you want to go back to the 1800s. And my concern is that by leaving in the phrase beyond the official power is that enterprising claimants could say that anything and everything that the local government is doing is beyond its official power if you can't find the specific right in statute. I think deleting that language leaves us in the same place, and no one would question the fact that local governments cannot act in violation of the Constitution or even of a state statute. That's what would be left here, and again would mirror what the state law provision is on the previous page. And then finally, on line 109, again, to make it match up with what the state waiver talks about, I would suggest deleting the last phrase or a local ordinance. For the waiver for the state, again, on lines 47, 48, it says that these claims are only available for alleged violations of the Constitution of the state or the U.S. It does not make a waiver for claims that the state is violating some state statute. For consistency's sake, if we deleted local ordinance in this phrase, then we'd be left with claims being available against local governments where the allegation is that the Constitution of the state has been violated, the Constitution of the United States has been violated, or any state statute. Again, I think for consistency's sake, that simply mirrors what the bill already talks about for the state. I think those are relatively minor, Mr. Chairman, and would ask for the committee's consideration of those changes. And thank you again for the opportunity to speak. Happy to try to answer any questions if I can.
Let me start out, if I might, Mr. Ramsey. What if you had a local government that awards a contract and the questionable conduct of that local government through one of its officials, maybe like the procurement officer, making some changes that are not part of the normal policy as to how these contracts would be awarded. And someone wanted to question that through a court proceeding, saying, I think what they've done is they've changed their regulations without cause. We wonder why that, you seek then perhaps to go into court and ask the court to grant injunctive relief. Would you be able to do that with the proposed language that you have suggested?
I would say probably not directly against the governmental entity, but I think there are a couple of claims that come to mind. One is mandamus. If the local government official is not taking an action that he or she is supposed to, the sovereign immunity does not bar mandamus claims. Also, we're talking about here claims against the government and officials in their official capacity. I would suggest that if you have a official who's acting outside of the scope of the bid, the purchasing ordinance, or whatever that is in play, then that's not an official capacity claim. That's an individual capacity claim, which is still viable and is not affected by sovereign immunity. Now, official immunity comes into play there, but it's not a sovereign immunity issue. So I think those claims would still be available in the fact pattern that you're talking about. It wouldn't directly be an injunction claim against the government, but probably against that official in his or her individual capacity.
The action would be, what type of action? Would be injunctive relief against that party, or?
I think you could. I think there's, depending on the fact pattern, there could be a mandamus claim, which will lie against any official for he or she to take actions that he's supposed to by law. Again, if it's an individual capacity claim, sovereign immunity doesn't apply. And so any other claim that might be brought, an injunction to prevent an official from acting in a certain way, a declaratory judgment asking the court to declare that he or she can or can't do what's being proposed. I think all of those would still be viable claims in the situation that you're talking about.
The one I'm talking about, and this was a case I'm familiar with, about naming parties, but you had a local government put out proposals for bid on a structural contract, and as part of that award, and I'm sorry, not the award, but as part of preparation to receive proposals, the procurement officer made unilateral changes in the language of what they would have as far as the criteria for receiving an award. And the party who was harmed by that did not get the bid because someone came in under bidding that would not have otherwise have been qualified but for the changes that were made.
Right.
And so the one who lost the bid sought to have the court stop the awarding of that contract. So I don't know if mandamus would allow there and say, well, you had language that permitted in the standards of the procurement, and so they received an injunction, temporary injunction, 30 days, and during that time were able to do discovery, and out of that discovery it became known that there had been emoluments was given by this bidding party to the one who won the bid. I'm sorry, the procurement officer. 2 weeks vacation, you might say, at a vacation home he had in Florida, condominium, and so realizing that was not the appropriate thing. My point is, if you say only as to ordinances, things like that would not potentially have the ability to be uncovered except by means of the court stopping it and allowing further discovery to go forward to mindfully find out what was behind the changes. So that's what I'm, and I let me say, as far as the state, I don't agree with the state's doing. This is the governor's bill, that portion of it. We got it in two parts, part 1 and part 2. And so we're accepting what the governor's point is on that at this time. Wasn't going to get into a contest with him about it, but the bill we had 2 years ago, you may recall, was a broader coverage of injunctive relief and declaratory judgment. And I just say that in the sense, I've been a local government lawyer like you have been, and for the most part, I've always felt the government did the right thing. But I do know from experiences within the government as well as outside, they do not always act properly through their personnel.
And I would agree with that, Mr. Chairman. I've seen that as well on rare occasion. I think the fact pattern you talked about is relatively extreme, and you're probably talking about some criminal behavior there as well if you're taking what sounds like bribes in effect. So you have that issue. You made one of the points that I was going to make as well as compared to the state language. If you were talking about a state procurement, this language in the governor's portion of the bill would not allow for potentially would not waive sovereign immunity of the state as to in the fact pattern you have. But again, I do think in that type of situation, aside from sovereign immunity, there will still be claims that can be brought against that local government official if he or she does not have the authority by ordinance or state law to be changing bid criteria on the fly. Then he's acting ultra virus, and that is.
But how would you find out without seeking and obtaining a temporary injunctive relief to be able to allow the further review through discovery, things like that? See, that's where those tools are necessary.
I understand, and I think the answer there, from my perspective, would be it would have to be individual capacity claims, and those would be available in that situation.
Thank you. Yes, sir. Mr. Fleming.
Thank you, Mr. Chairman. I was doing my best to follow this erudite discussion between the chairman and
you're also a local government lawyer.
That's why I ask you questions when I have them, Mr. Chairman. So I think, Mr. Chairman, the point that you were making, that you would object to Mr. Ramsey's 3 suggestion was striking or local ordinance on line 109. Is that right?
Yeah, as far as looking at that portion of that, I'm saying that is something that has some.
That's the point you were making.
The 106 between relief and 2 insert from enforcement of a local ordinance. That I think limits it, because the granting of a contract in some jurisdictions might be called an ordinance. Others are just awarding a contract. It depends on how they look at it. So I can't always say that doing contract work is going to rise to the level of being an ordinance.
So basically his change on 106 and 109 is what you would object to there.
As about.
What about that one in the middle where he was talking
haven't
about some
looked at it yet.
clarifying language
I
on
haven't looked at it.
107? Okay.
And I apologize for just getting the sub today and not having the
Oh, it's
chance
all
to
right. Yeah.
submit these comments before
Certainly.
now.
Could I ask then, Mr. Chairman, from maybe if because I was interested in your opinion on that line 107 change he was talking about also for clarity's sake, could we flesh that out maybe with Mr. Ramsey so that you can see how you feel
Sure.
about that one?
Mhm.
Talk about that, Mr. Ramsey, on line 107. You thought by taking out the words "without lawful authority beyond the scope of his official power" would be clarifying rather than.
That's right, Chairman Fleming. The issue there, again, if you take those phrases out, then you still have declaratory and injunctive relief available for alleged violations of both constitutions, state law, and or local ordinance, depending on whether that language stays in or not, which again would mirror or actually go more broadly than the state waiver on the previous page. And I don't, from my perspective, there are two problems with the language that I'm suggesting be taken out there. One, it's redundant. There's no question that local governments can't act in violation of the Constitution or state law. But also, as I mentioned earlier, because of the 100+ years of case law that indicates that local governments can only do those things that they can find in state law, specifically authorizing them to act, I think those phrases are a little broad to say acting beyond the scope of official power. That sounds valid. I think it's on its face, it's hard to argue against that. I just know the devil's in the details. If we take those out, I don't think you lose anything substantively because you still have the same claims based on constitutional or statutory violations.
Would that be true of declaratory judgment?
Yes, sir. I think we're talking about for both of those, both injunctive and declaratory relief.
I'll give you another example.
Okay.
We'll talk about textbook examples. This is another case that I was involved in. And in DeKalb County, many years ago, I was not the county attorney then, I was in private practice. But the county decided that the people in the plumbing business were not responding in, say, a sufficient time to clear out drains on private property. And so the county decided to go forward with buying these, I call them rotor-rooter type trucks, about several of them. And in effect, we're going into competition with the private businesses. And so what would happen in the past is that someone who had a clogged up sewer line, first thing he would do is call the county. Of course, the county, my sewer line is clogged up, you need to fix it. So the county comes out, looks at it and says, oops, here's our line, public right of way. This side of the right of way is our property. The inside part, private property, is your problem. And you got a tree over here that's got roots growing into it. So you need to call a private plumber. And this went on for years and years, of course, like that. And they'd have to call a private plumber. It may take a day or so to get the plumber out there to open it up. So the county said, well, we'll just start doing it ourselves rather than requiring the homeowner to get a private plumber. We come out there and find there's a problem. We'll clean it out and just charge them the $150 or so. The question was, do they have the authority to do that, of course? And they said, well, we got a right to have sewer lines, right to maintain sewer lines, we have a right to maintain sewer plants, blah, blah, blah. So the matter went to Superior Court. That court ruled in favor of the county, but it was appealed to the Supreme Court. And I remember Justice Smith, George Smith, writing a very scathing decision telling the county you cannot go out and compete with private business, which is true. I think either constitutionally or by statute there's limitations what you can do there. So it was done as a declaratory judgment matter, though. So what was your authority? Did you have that kind of authority or not? So I'm questioning that. That's why I say about without lawful authority beyond the scope of its official power.
Well, as you said, Mr. Chairman, and I'm familiar with the rule, although I haven't traced it back. It's long been the case that, and long line of cases saying that government can't get into the business of competing with private enterprise. And as you said, to the extent that's a constitutional or statutory prohibition, that claim would still be viable here. You could bring a declaratory or injunctive claim for violation of those state level
Okay.
prohibitions that you're talking about in that situation.
But aren't you, by deleting without lawful authority beyond the scope of its official power, questioning whether you have declaratory judgment now to address how they have adopted a policy or ordinance, in this case doing something that is beyond what they are legally capable of doing, to have the court review that?
So what you would have if, and I understand your point, I believe, Mr. Chairman, you'd still be left with language that says you could bring a claim against the political subdivision seeking declaratory or injunctive relief, and then I'd inserted some language in violation of the Constitution of Georgia, the Constitution of the United States, state statute, or a local ordinance. So you still, again, would have those same rights, both declaratory and injunctive. And again, I think all of this is assuming that you can, as the bill says, assuming you can meet the other standards for getting declaratory relief or getting an injunction. That's not changed. That either of those claims, I think, would still be available to you if that political subdivision is acting in violation of state prohibitions on competing with private enterprise.
Right. So your concern is it may be redundant.
It's redundant, and again, I think it's broad enough that enterprise, it's an exception that could potentially swallow the rule because of, as I mentioned, the long couple of 100 years of case law that applies this Dillon's rule, that anything you can't specifically point to as specifically authorizing this authority is in excess of your powers. Now, I can quibble with whether that should be the law because we have a home rule amendment now that gives local governments broader authority, but nevertheless, that case law is still out there and is still viable. And again, I do believe it's redundant, so I don't think anything's lost by deleting that.
All right. Any other questions of Mr. Ramsey? See none on the panel, so appreciate your coming before us and
Thank you,
your
Mr. Chairman.
comments. Next we have is Bill Clark with the Georgia Trial Lawyers Association.
Thank you, Mr. Chairman, members of the committee. Rather than begin from the beginning, I want to try to tackle just a little bit of what Mr. Ramsey just brought before you. This is on the far edges of what I know about the law, particularly when it relates to local government authority. But it seems that the argument Mr. Ramsey has put forward is local governments cannot act without lawful authority, and they cannot act beyond the scope of their official power. Therefore, we need to take out of a bill that waives sovereign immunity the opportunity for citizens to challenge them when they have acted without lawful authority or beyond the scope of their official power. And so I would submit to you that those phrases ought to remain in the bill so that citizens who believe their local governments have acted without lawful authority or beyond the scope of their official power, that they would have the ability to bring that to court, if for no other reason than, as the chairman pointed out, oftentimes we don't know what went on until we can get a stop brought to it and discovery can be had so that the parties can find out what is going on. There are plenty of cases, particularly in the tort area, where nobody knew until they could do the discovery, and then they found out the misdeeds that were going on. So we would ask that you not adopt those changes. Let me go back to the beginning, though. We have been proud to work on this issue with Chairman Willard and with this committee going back to 2015 in the wake of the Sustainable Coast decision. And it's because, as practitioners for the last 2 decades preceding Sustainable Coast, we all thought that a citizen had the right to bring an equitable claim before our courts to get declaratory judgment relief or injunctive relief when their government acted either in violation of the law or in violation of the Constitution of the state or of the United States. Sustainable Coast, I think, correctly determined, hey, if you're going to waive sovereign immunity, the legislature has to expressly do that. And since they have not done that yet, then we have to find, the court had to find under the law that the citizens did not have the right to have equitable relief because the legislature had not waived sovereign immunity as you did
for tort claims, for example, with the State Tort Claims Act. So on the law, I think the court got it right. And so now the question is, does the legislature want to take up the public policy decision of whether we ought to allow the citizens of the state to have equitable relief against local governments and the state government? And so we applaud the committee for taking up the issue, and particularly Mr. Chairman, for your leadership on this. As with lots of issues, we don't believe, particularly with the state portion, that the bill goes far enough. Somebody's going to ask quickly, well, if you go too far, isn't Governor Deal going to veto this one too? And that's a fair concern. But I want to at least make the public policy argument of why we believe the bill ought to go farther in Part 1 as it deals with a state. Right now, the only thing a citizen would have the right to bring, the only type of equitable relief a citizen would be able to seek under Part 1 of the bill is if the state legislature passed a bill that was in violation of the Constitution. If it was an unconstitutional law, that's the only challenge you get. But under the first part of the bill, if government agencies, if the Department of Natural Resources, as the entity that was involved in the Sustainable Coast case, if they chose to violate the state law, your constituents would have no equitable remedy to bring. Sustainable Coast was about a permitting process that this legislature had passed into law requiring developers to go through if they wanted to tear up coastal property, if they wanted to develop coastal property that appropriately protected under state law. But the DNR decided that was problematic for developers, so they came up with this workaround that allowed developers to go around the state law and to begin developing property. So this group, Sustainable Coast, on behalf of property owners down there, brought the case seeking an injunction to stop the development because it was in violation of state law. And the Supreme Court, again, correctly, held that the legislature has not waived sovereign immunity for equitable claims. And so, sorry, Sustainable Coast, sorry, property owners, you have no remedy against the state agency violating clear state law. Under the first part of this bill, if it were to become law, citizens of Georgia still would not have that relief available to them. They would not be able to bring equitable actions to stop a state governmental agency from violating the state law. We think that if we're going to be a government of the people, by the people, for the people ought to be able to bring an action to stop its government from violating its own state law. And so that's our overarching public policy argument. In connection with that, we believe a change should be made in the bill at lines 47 and 48, which right now just allow sovereign immunity is waived only to seek declaratory judgment relief from the enforcement of a state statute based on its unconstitutionality. We would ask, and I'll be glad if at the right time, if Mr. Chairman will allow me to suggest that we amend that to add in not only challenging the constitutionality of a state statute, but that one should be able to get injunctive relief from action by the state that was, and I'm parroting the language that Mr. Ramsey was concerned about over in the local government part, and that is if such action, the state action, was without lawful authority, beyond the scope of its official power, or in violation of the Constitution of Georgia, the Constitution of the United States, or a state statute. And so that would give broad relief to the people of Georgia whenever its government is violating its own laws or its own constitution through its actions, legislative or executive branch. Second issue is just a question that we posed to the committee, and that is on lines 60 through 61, and again over on 119 through 120, where the phrase exists saying that this deals with the private right of action prohibition. This article shall not, reading on lines 60 and 61, this article shall not create, imply, or otherwise provide a private right of action. I know the intent here was to make sure that an individual, a citizen who is being harmed, will have a right, but not, for lack of a better term, a do-gooder group that just wants to bring the claim on behalf of others. I believe the intent was to say if you are being harmed, it's up to you to bring it. You don't go get whatever your organization that would support you. You don't get them to bring the cause in their name. It has to be brought in the name of someone who's actually harmed. And you handle that when you use the phrase aggrieved person. you say that the only people who can bring these claims are aggrieved persons. But we believe that this sentence that says the article shall not create a private right of action, we think that's exactly what this article is to do, is to create a private right of action for citizens. So we're concerned that as written, lines 60 through 61 and 119 through 120 arguably gut everything that we're trying to accomplish if a court were to interpret it that way. Our last concern, and this is really in the meat and potatoes of the bill over on the as it relates to local governments, and that's over on lines 103 through 109, and and Mr. Reed and I have had lengthy discussions, as the chairman and I have had, about how do you word this so that you want to make sure that somebody actually has to have skin in the game to be able to bring the claim. And the phrase that was chosen, written by Ms. Travis in the bill, was to require that it be an aggrieved person, and that it says that they could seek relief on line 106 to remedy an injury in fact. Now, injury in fact is defined in a lot of cases in a bunch of different ways. So what are we talking about when we say they've got to have an injury in fact? Our concern is that a straight reading of that means, sorry, Mr. Clark, you haven't been injured yet, so you can't bring an action for declaratory judgment or for an injunction. Come back after you've been harmed. Come back after they've ripped the sand dunes off of your property. If something can be fixed, come back then. And so what we would suggest is we're really concerned about the threat of imminent harm by the government. And the case law, in fact, defines injury in fact in a case. I've got the cite for you if you want it. But it says it includes a threat of an injury that is actual and imminent, not conjectural or hypothetical. And so we would suggest that after the words injury in fact, you put in a phrase that says, comma, including a threat of such an injury that is actual and imminent, comma, not conjectural or hypothetical, comma, and caused to such person. And so you address our concern about what is imminent, what is an injury in fact, by adding that language. We are very supportive of the bill, and we'll be supportive of whatever this committee and ultimately this legislature is willing to pass and the governor is willing to sign. If I may, Mr. Chairman, distribute the two suggested pieces
Yes,
of
sir.
language, and if someone is willing to offer it, then we would ask your support for it. There they are, Mr. Reed. I'm glad to answer any questions. Again, as I said, we will support whatever the committee comes up with, but we felt really compelled to bring forward this broader public policy issue about making sure that on the state part, that it's not just the legislature who can be called on the carpet by our citizens, but so can the executive branch through their agencies and departments that may violate the law or the Constitution. Thank you,
Thank
Mr.
you.
Chairman.
Keep seat with for a second. Let me also mention to the audience and to the committee the one area that we did make a change. I say I did, in the section that deals with the governor's portion of the bill, was a question about a filing of a what we'll call a lis pendens notice. And although it wasn't referred to that way, it was requiring that before you could bring an action against the state on this particular challenge, that you had to send a notice to the Attorney General and the director of the department that was involved with whatever action was being challenged. I felt that was not in the interest of either the state or the public, because too many times the waiting of that 30 days before you can do anything, conduct will already have occurred that may be the damage that they were trying to prevent happening. And just as you have lis pendens with local governments, but you're not held up if you need to take action on some imminent harm, we'll call it. Now, what we did, or I did, is if you look on line 86, the code section 502155 just says that no suit making these type of challenges can be taken without having proper service made on the Attorney General or his designee and the state governmental entity that is charged with the enforcement of the state statute being challenged. So I was trying to address the concern the governor had. I think what's happened in the past is you may have the supervisor on the road job being served or someone of that nature on behalf of the state, and that was all. And then later realize that something's happened, and the question is whether it was good service or not. I felt it was appropriate and necessary to have in here a direction as to who would be in fact served for that type of action against the sovereign immunity question.
Mr. Chairman, we agree with you. That was the last point I was going to make, but frankly just forgot to make it, and that is ante litem notices in tort claims, for example, in the State Tort Claims Act, which is what the governor's lengthy section was intended to mirror. That makes sense because you're trying to give the government and the individual party the opportunity to settle the case before there's a lawsuit. Well, there's no settling a case when you're asking for a cessation of conduct or when you're challenging the constitutionality of a statute. Either they shouldn't be doing what they're doing and the court will say so, or it's okay. It's not an opportunity to settle the case as there is in a tort claim. The other problem is that often statutes, and this is particularly relating to challenging the constitutionality of statutes, often the challenge is made in a private cause of action, citizen versus citizen. An easy example, let's say there was an unconstitutional cap on damages that the legislature passed. Well, the only time that could be challenged would be post-verdict, when the plaintiff got a verdict in excess of the cap. And that's exactly how the Nusselhut case that struck down the cap on damages in 2010 came about. The first time it was raised, and the only time it could have been raised, was by the plaintiff after receiving a verdict in excess of the cap. Prior to then, it was not a ripe issue. So how would that plaintiff follow a 30 or 90-day regimen as was in the bill earlier? As the chairman has suggested, if all you have to do is provide notice on the constitutionality issue, if all you have to do is provide notice to the Attorney General and then to whichever agency is charged with enforcing that statute, that could be done in the short time frame that would be required in the midst of a private cause of action.
Thank you. And as it says, we got to have that proof done before the court is to conduct any hearings. So we want to be sure that the right people have been notified and they're there in the court representing the state in that instance. Ms. Oliver, that's your mic?
Yes, sir. If I may, there are two matters I'd like to ask you about. Line 61 in relation to the private right of action. Your comments there seems to overlay with some of the case law relating to standing. An environmental group, the Sierra Club, sues because of the dumping in the Altamaha River. They don't have standing. I'm interpreting your comments as narrowing the opportunity for an entity like the Sierra Club to bring action.
My comment was observing what I've heard among those sponsoring the bill, that they wanted to limit that so that the Sierra Club, Georgia Carry, the ACLU, whichever group out there that would do this, the sponsor, I think the chairman can speak for himself, but I think others have said, we don't want all these groups being able to file these. We want somebody who is an aggrieved person.
And my question to myself, because I don't know precisely where the case law is right now.
Neither do I.
Does this language narrow where the case law is in terms of a Mr. Reed's lowering his...
It would when you look at the fact that we're waiving the issue of sovereign immunity and we're putting certain prerequisites there as to how you do it
So
and
that
what
troubles
you
me.
can do.
The
And
other
of course, you, as a official thought is, I think any public interest group can always find, quote, the aggrieved person and represent them, but it's just, you had to bring it in the name of individuals or parties who are in fact injured. Yeah.
So that's, I'm concerned about that. The other thing, I'm trying to think practically, pragmatically about the difference of an ordinance and an action by a local government. I'm thinking about cases from way back in my youth. The county health department denied prenatal care to unwed mothers. I think that was a policy, but not an ordinance. it may have been constitutional. Would this language have prevented the young woman needing prenatal care from suing on that action? Similarly, on today's rule, if DeKalb County decided that it wanted to, by policy, impose a work requirement in order to get health care benefits, does this language prevent them from?
I'll now, I've been joined at the table by the legal scholar, Ms. Travis. She may want to take a stab at that, but I think there is a difference between saying that a government is violating the law, violating a statute, violating the Constitution, and I want to challenge them for doing that. There's a difference between that and saying, I don't like the public policy decision they've made, and I want to be able to sue them over that. I think there's a difference there, and I think that's a public policy decision you all have to make. How far do you want it to go?
And that's exactly where my question to myself is. Do they have to have passed, the North Georgia County that denied prenatal care to unwed mothers, did they have to pass a local ordinance officially in order to be sued? Or could simply the intermittent action of such a policy be sufficient for them to be sued?
I don't know the answer to that.
I won that case, by the way. But
Maybe they could.
You will bring,
I don't talk about that.
Maybe the
You
answer
bring
is
up
if
the
they
ones
have
I
a really
lost.
good lawyer, they can do that.
all right. Mr. Welch, is that yours or? Yes, sir.
Thank you, Mr. Chairman. Going back to some statements you made earlier, Mr. Clark, my recollection was that if a party felt like the executive branch or an agency of the executive branch was acting in a manner that was beyond their authority, they could bring a declaratory judgment action under the APA. So we do have my understanding is we do have a procedure for that currently. Now,
Oh, okay.
Well, I think that's now an open question after Sustainable Coast and the Lathrop decision. Do we have that? Is that?
it didn't alter Justice Melton's decision, and I'm blanking on the case name, but when the court then overruled the declaratory judgment action that had been filed on behalf of some students who wanted, I guess, I think admission to the University of Georgia or tuition.
Olvera?
Olvera, yeah. So that, in that decision, he made clear that that was an open avenue that they had not pursued.
I'm not aware of that.
So
Part of that holding.
That's OCGA 501310. And then
Okay. His concurring,
he wrote the opinion.
he wrote the opinion, okay.
Yes, sir. So I'm not sure that that's 100% accurate unless I've misread that case. I don't think I have, but something to think about, that there is an avenue, but that does not resolve the other issue of injunctive relief that you're seeking, that you're discussing here. So that would not provide that same remedy.
So the APA allows for declaratory judgment, but not for injunctive relief.
Correct.
I wasn't aware of that. I'll take a look at that. I mean, that's the goal is to make sure that the citizens have that right to pursue either equitable relief option, so that the government can be held accountable when they're violating state law or the Constitution.
Yeah, I share that sentiment, but I think that we may need to look at that code section as well.
Yes, sir, Judge Caldwell.
Thank you, Mr. Chairman. I guess it's a statement and a question. I'm looking on page 4 at line 105, and then also for the amendment that is offered, of course, by Mr. Clark. And both of these are talking about an aggrieved person. And, of course, the statement has been made, we're trying to get to people and not to corporations and entities, as Representative Arler was talking about. But under state law, a corporation is a person.
Right.
So I think we're going, and I think it was hit on in some of the chairman's statements, that we're may have to change this from person to individual or individuals instead of using the word person, because that would apply to corporation. I mean, that's just my concern if you start looking at the pure letter of the law.
I'm certain there's people behind me that represent more
Yeah.
corporations than
Yeah.
I do, but we would stand with them in making sure that a corporation, if they were aggrieved by the government violating the law or the or the Constitution, that they would have the same
Yeah.
right as the human being.
Well,
We-
what
we-
I was saying was that the statement was brought up, the whole purpose of trying to get this is so individuals could do something, not the Sierra Club or some other entity. I'd just use that as an example, and by using the word person, it wouldn't do that. It would apply to them, in my opinion, because they are a corporation.
Yeah, so, let me say,
Fair
the
point.
term person, aggrieved person, and I looked at my learned counsel here, means individuals as well as other entities, legal entities,
Yes.
by law, yeah. So we're not limiting it from corporations or LLCs or partnerships, whoever be harmed as a quote, party person.
Right.
Okay, sorry about that.
Well, I only brought it up because it was said
Yeah.
we're not talking about the Sierra Clubs and those types of entities. That's the only reason that I brought it up. That would include them under this.
If they meet
They're
the aggrieved,
corporations, yeah.
if they meet the aggrieved part of that.
Aggrieved,
Right.
yeah, aggrieved.
Right.
And aggrieved is recognized someone who has that harm being caused to them specifically. Okay. Anything else, Judge?
No, sir. Thank you, Mr. Chairman.
Yes, sir. Mr. Clark, anything, no further questions, anything you want to add to it at
Nothing,
this point?
nothing, Mr. Chairman. Thank you, Mr. Chairman, members of the committee.
And we have one other signed up individual, Thomas Weaver. Okay. Good afternoon, Mr. Weaver. Give us your name and you represent yourself, so I understand.
Thank you, Chairman Willard. Members of the House Judiciary Civil Committee, I rise today in my capacity only as a private citizen. I don't represent anyone or anything, and all my thoughts and comments are my own and do not reflect on anyone or anybody else. However, I do rise today and I do ask that this committee grant favorable approval and hopefully a due passage recommendation on House Bill 791. I do think that it's an important public policy question that's being meted out by this House and this Cameral in regards to an ability of a private person to be able to bring suit whenever the state causes the enforcement of the state statute for which a citizen is aggrieved because the citizen feels that it's violative of the Georgia Constitution. However, I do have a few concerns I'd like to add in addition to what you've heard from the two other speakers. And again, I don't know if it's legally correct for me to I don't know if the language is covered under the bill or if it's been covered by what the speakers have already shared, and I don't know if it's addressed elsewhere under the code. But two thoughts initially strike me is that when you define the term state entity, and I don't have the current LC number that this committee is working off of, it wasn't on file with the clerk, so forgive me for not being able to cite the line number. But when you look at all the agencies, authorities, boards, bodies, bureaus, committees, commissions, departments, districts, divisions, entities, and other instrumentalities and offices that the state creates, usually when they're teed up under a department scheme and they're headed by a commissioner and there's a board, they can promulgate rules and regulations which go on file with the Secretary of the State. And I would ask that in addition to state statute, whenever a citizen feels the state statute is violative to the Georgia Constitution or perhaps even the United States Constitution as was addressed by previous speakers, I would ask that this committee consider the appropriateness as to whether or not it would be permissible to include language under this bill that would allow the citizen to bring an action if the citizen felt aggrieved for declaratory relief or injunctive relief as against a rule or regulation promulgated by any of those entities that they're otherwise authorized to promulgate, that the legislature has allowed them to promulgate by operation of state law where you've delegated that authority to them, but where they abuse or misuse that delegated authority and they create a rule or regulation, a policy, or an internal memorandum or something of that sort that is violative of the state constitution or the United States Constitution. So again, I do ask that if it is something that's within the scope of public policy, if it's compatible to what the committee is trying to do here and create a better product, and if it's something that wouldn't dare I say, become too broad, that might meet gubernatorial veto by Governor Deal, If that's something that could be considered, I would be greatly appreciative as a private citizen, because I do think that citizens, not only should they have the ability to bring action on the basis of a statute that they feel is ultra vires to the Constitution, but I do feel that they should also have that ability in regards to rules and regulations, which, mind you, are promulgated administratively internally. So there is no course of redress. They're not, the persons who do that are not elected officials. So that you can't, a citizen, a taxpayer, a voter, they can't be held accountable the same way that your constituents can hold you accountable for the choices you make here. And then secondly, I'm looking at this bill, and maybe perhaps this is addressed somewhere else in the law, and I might be completely wrong, and Ms. Travis is here, I'm sure, and she could tell you if I'm just flat wrong, but something strikes me under
She tells me a lot.
yeah. Well, you know, and she's right, but every time she ever speaks on anything, she's always right for the most part. And I've learned that through many committees. But something that strikes me here, seriously, it says that you cannot bring an action by, on behalf of, or for the benefit of someone who's incarcerated in a penal facility or a state mental health facility. And to the extent that someone is incarcerated or is not free to leave or has been deprived of their liberty in a penal facility or a state mental health facility, I don't know what the driving force behind that is. I guess, just again, this is a guess, but I guess as a private citizen, that's to detect and deter malicious and frivolous litigation. But my concern is that if the imprisoning authority, whether that be an agency, an administration, the Georgia Department of Behavioral Health and Developmental Disabilities, perhaps a court, however that person got there, what is it then in regards to habeas corpus relief? Again, maybe that's addressed somewhere else in the law, but if a person is imprisoned in a state mental health facility or a penal facility and they wanted to bring an action before the courts, under their Article 1, Section 1, Paragraph 15 right, and their Article 1, Section 1, Paragraph 12 right under the Georgia Constitution, to have access to the courts and to be able to prosecute and defend their own action in the courts and for habeas corpus relief, if they feel that the statute, or in the case that I posture, maybe the rule or regulation that's being used to hold them, if they feel that that is prohibitive or constitutionally infirm, shouldn't there be an allotment here at least for habeas corpus relief? And maybe it might be that that's already covered under another provision of the code. Maybe. And that's what I'm saying. I don't know the answer to that question, but I would be remiss if I failed to address it publicly, and I do ask that the committee at least digest that thought in moving this bill. I know that it's not specific to what it's trying to accomplish here, but it just strikes me as something that might want to be given consideration, because the Georgia Constitution does go out of its way. The people have gone out of their way to say habeas corpus relief shall not be denied. So I do think it's relevant if they feel that the statute, or in my case, the rule or regulation that's being used to keep them is not kosher.
Very good. Thank you, Mr. Weaver. I agree with you. I think habeas corpus is covered by a separate provision of the
And
Constitution,
it may be.
and that's certainly important that we keep that in mind.
I just
So much so.
concerned.
Thank you.
Thank you.
Thank you so much. Also, I believe Mr. Patel, Russi, come on up. Introduce yourself and tell us who you represent.
Thank you, Mr. Chairman. I'm Rushi Patel with the Georgia Municipal Association, and I apologize for jumping in on this late. I wasn't planning on testifying, but some of the testimony from Mr. Ramsey and Mr. Clark got my mental juices going, I guess, and I wanted to present a idea or a thought on Mr. Ramsey's suggestion on lines 107 to 108, striking from without to or. And Mr. Holcomb, I have to apologize to you in advance because you've probably heard enough about booting of motor vehicles for a lifetime after all those hearings in public safety. But it got me thinking. Georgia law currently states that from private parking lots, people can tow motor vehicles. It's nothing in Georgia law about booting motor vehicles, but many local governments, but many local governments have found this to be an issue. Some have passed laws, ordinances setting standards, and others have just outright prohibited the practice. So if you keep using that as an example, and I may be opening up a can of worms that I may not want to, but using that as an example, some local governments have prohibited the practice of booting motor vehicles. And an argument could be made, if we leave this without lawful authority language in here, that those local governments are acting without lawful authority to prohibit such practice. So that's an example of what Mr. Ramsey is talking about, I think. Because if you strike that language, there's nothing that would create that as a violation of the Georgia Constitution, the U.S. Constitution, state statute. But I think someone could make an argument that those cities are operating without lawful authority and prohibiting the practice. Now, those cities or counties would be saying, we're doing that because there's been violent incidents and all these things that we found, and we're acting under our home rule authority. And I think you'd get into a litigation issue, but I just wanted to bring that as an example.
Well, if you have, from that side, the argument that they are no longer able to control or limit it, what about the other side that says, well, wait a minute, there's nothing that gives you the authority and power to do that, and we want to challenge that ability. Because the state has never said, in the enumeration of powers given to the cities and counties, something may specifically encompass booting cars.
Right, and I think that's exactly
That's the point.
right.
You can control traffic, you can do all the things maybe of that nature, but as far as having cars, or, I'm sorry, having individuals or companies authorized and by licensing and permitting them going on private property to do the booting, so that's beyond the authority. Either way you look at it, it could be challenged.
I completely agree with you. I just wanted to bring that as an example of the
Good
fun
point.
mess that could create.
So we gotta look at without legal authority both ways.
Mhm.
Thank you.
Thank you, sir. Thank you, members of the
Thank
committee.
you. Anyone else wish to address the committee at this time? I'm not going to be having a vote today. This was for the purpose of airing thoughts and opinions about the bill before we have the bill come back around either Thursday, I'm not sure exactly when yet, for a further review and vote. And I'll probably have it open again for public comment at that time, since the presenter of the bill is not able to be with us today. I want to say to the committee one other thing that I've heard recently, and I've also looked at my representative of local government council. We've got cases that are pending right now in state courts locally, where the argument's been made and the courts are agreeing that there is not the right of a citizen to challenge zoning. Folks, if that gets up to the Supreme Court and they concur, I think we'll probably have a revolution on our hands. I'm telling you, I mean, that would be the I think the downfall of a lot of people if that were to be, in fact, and they're saying, the judges I've talked to, I say, I've read the cases, it's been briefed by the parties, and I have to agree, at this juncture, we don't really have the ability to question the authorities of local government on zoning, because what you're dealing with there is usually involving a form of declaratory judgment relief as to what is the constitutionality of a enacted ordinance on zoning or rezoning. So, Mr. Welch, you might want to add into that.
No, that's exactly how I was reading after the Olvera case, that was in a sense barred, but then we since have had the diversified holdings decision that came down end of last year, which then suggests that it would be by writ of certiorari. It's a review of an administrative decision or a quasi-judicial decision. The zoning decision itself would be a property by property decision. And so on each one of those cases that you have a zoning decision made, it appears under that case that the only way to get to a court review would be by writ of certiorari, which itself is a fairly antiquated process to get to Superior Court and wrought with lots of procedural pitfalls.
How many times if I had a case dismissed,
Yeah.
somebody bringing a writ of cert and then follow the exact specific step-by-step rules and getting to court.
That's right. But then even if you wanted to change, if you wanted to challenge the adoption of a zoning map, so this would be purely legislative.
Yes, sir.
There is no, what is the cause of action?
Mm-hmm. Well, that's what I say. The things looked at as part of declaratory judgment in reviewing the ordinance itself as to whether it was constitutional or not.
But what
But
is
you
our
can't
co-
do that. Yes, sir. Mr. Fleming, my other.
So, Mr. Chairman,
learned
I fear,
local
I
lawyer.
fear sometimes I wake up in the middle of the discussion but I want to make sure I understood. I thought the Zoning Procedures Act provided for the ability to appeal decisions to Superior Court. It does not?
I'm not arguing whether it does or doesn't. I'm just saying it's now in local courts, this
Mhm.
issue is being raised, and judges are saying, in reviewing the law and the briefs that they're citing, the fact there is not the ability, on whatever way the action may have been brought into court, for the court to rule on that zoning question.
The zoning procedures goes to the procedure the local government is to follow
Yeah.
in order to meet the minimum due process. But I don't recall there being any provision as providing a cause of action under it.
So the provision for appeal to Superior Court is not in there. It's always been an equitable.
Yes, sir.
Okay.
So that's the another thing that say percolating up that I think should give us pause about not passing something to in fact give the people of our state who we represent a right of redress before the courts as another branch of government, something being done improperly by another branch of government. Ms. Travis, you weren't here earlier, but you have before you some notes of some things that people have made recommendations, you might say, of either changing or adding to the current bill 791. So I don't know if you had a chance to look at them or we'll make any comment about that while we're here. And I have to get you by the phone or by the mic if I can. I know you don't have one right in front of you. The people in Alaska listening to this debate. Well, that was provided to us by Mr. Ramsey, right? Yeah. Okay. All three of them are? I said there's three of them there. Three different ones. Be careful. You weren't hearing my early comments about it. Yeah. Well, we'll do some looking at it between now and the next meeting to see. The other one that I think Mr. Clark had was on line 106. And I know we have an injury in fact, and we've had discussions about this, and maybe to put belt and suspenders on this point, adding in there or imminent harm. Just so that a judge down in Ludwig, Georgia, reading this, he may think you gotta be in fact hurt before you can do something, as opposed to having potential harm coming to you. So that'd be the imminent harm question. Okay. Well, I want to say, of course, this is under the section Part 1 question, and what we've done here is taken the governor's floor leader's bill, and except for the question about the service issue on the in-line notice, we made the change there, but we didn't really go into the content of the bill itself making much change, or any change. Yeah. I think they want to broaden the language to be recognizing statutory challenges, meaning something you challenge the language of a statute besides just the Constitution, right, Mr. Clark?
Actually, Mr. Chairman, the second part isn't about a statute, it's
Mhm.
conduct by
Okay.
a department or agency that is violative of the law or the Constitution.
Okay. Mm-hmm. Okay. Well, we'll take that into consideration. So the thing we're trying to walk is that line of not having the governor again veto the bill. And whether we do this in building blocks as we go forward somehow. Questions among the, or discussion among members of the committee, thoughts about the bill? Mr. Welch?
If we're going to do this in building blocks, shouldn't the mason be around for the next session?
Perhaps so. Who's the mason?
You.
Oh, me? Oh, no. Oh, yeah. Now you're going meddling. Now you're meddling. Okay. Any other thoughts, questions, comments? If there's not, say we're not going to be taking a vote on this time. We'll perhaps be having further hearing on it Thursday, at which time we do. There will be some votes. We'll consider amendments. I want everybody to first digest where we are with the two bills being brought into one bill, the language of it, and if you have suggestions that you want to submit to amendments, we'll do it at the next meeting. I'd like to have you submit them to me ahead of time so we can have a chance to have Ms. Travis also take a look at it. You can do that. Everybody in agreement? With that, if there's anything else to come before the committee at this time, if not, we'll stand adjourned. Thank you.